Hi, my name is Elizabeth Rainwater, and I'm an attorney with the Georgia Justice Project and an Equal Justice Works Fellow sponsored by the Clorox Company. I'm excited to share with you that on May 3rd, Governor Brian Kemp signed SB 105 into law, making it effective immediately. SB 105 sets clear criteria for individuals to pursue early termination of their probation sentence. This bill will significantly impact Georgia, which has the highest rate of individuals on probation in the nation, and on average, sentences 3 times longer than other states. Let's talk about who qualifies for early termination under SB 105. In general, if you're serving a felony probation sentence out of Georgia, you're eligible for early termination if you've had at least 3 years on probation, not had any new arrests other than arrests for non-serious traffic offenses, have not had your probation revoked in the past 24 months, and have paid back all restitution. Restitution does not include fines or fees associated with your sentence. Now, there are different pathways to pursue early termination of your probation under, depending on the offense that you're serving your sentence for. Behavioral incentive dates, BIDs, apply if you're serving a probation sentence for your first felony offense and were sentenced to either straight probation or less than 1 year of prison followed by a period of probation. A bid will be 3 years from your sentence date unless the judge included an earlier date in your sentence. If you complied with the terms I mentioned before, so no new arrests other than arrests for non-serious traffic offenses, no revocations in the past 24 months, and have paid back restitution, then the Department of Community Supervision, DCS, who oversees felony probation in Georgia, will submit an order to terminate your probation to the sentencing court. The judge must then terminate your probation unless the prosecuting attorney requests for a hearing within 30 days. Even if you do not qualify for a bid, if you've complied with all the qualifications I just mentioned, then you may be eligible for early termination after serving 3 years of your probation sentence. When you become eligible, DCS will submit an order to terminate your probation to the sentencing court. The judge must then sign that order unless the prosecuting attorney requests for a hearing within 30 days.
You probably have questions about some of the qualifications or steps in the process that I've described today. To learn more about SB 105, the different pathways for specific charges, and next steps to take if you think you qualify for early termination, please watch our webinar on SB 105 by visiting the link you see on the screen, and continue to check our website for educational materials. The link is also in the description of this video. Our team at Georgia Justice Project cannot express how thrilled we are for the passing of SB 105 and the impact it's going to have for thousands of Georgians. The passing of SB 105 was truly a bipartisan effort, and we want to extend our gratitude to the many individuals and organizations who advocated for and supported this bill. We would specifically like to thank Senator Brian Strickland, Senator Bruce Thompson, Representative Tyler Paul Smith, and Nelson Mullins, as well as Faith and Freedom Coalition, the Metro Atlanta Chamber, the Georgia Chamber, Reform Alliance, and Restore Her. On behalf of GJP, I also want to thank all of you who are watching this video and are spreading the good news of SB 105 to your community. Stay safe, everyone.